Patricia Tuitt. And before I introduce our special guest speaker today, we always start our McLaughlin College lunchtime talks with the land acknowledgement. This meeting is virtual, and because of that, we are not all actually gathered in the same space. York's land acknowledgement might not represent the territory that you are currently on. And I would ask, if that is the case, that you each take the responsibility to acknowledge the traditional territory that you are on and its current treaty holders. As a member of the York University community, I recognize that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located that precede the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Tuitt has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, the Métis, and the Métis. It is now home to many Indigenous peoples. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Today's speaker, Patricia Tuitt, is a legal academic who works within the field of post-colonial studies. And she's a former dean of the School of Law at Birkbeck at the University of London. And she has published widely in a number of different forums, but I'll just list a couple of her publications, including books such as False Images, Law's Construction of the Refugee, Race, Law, Resistance, and she's also co-editor of Critical Beings, Law, Nation, and Global Legal Subjects, and also Crime, Fiction, and the Law. And she's recently published a number of academic articles that include Walter Benjamin, Race, and the Critique of Rights, including the Griffith Law Review, and also in Law and Critique. So I'm going to turn things over to Patricia Tuitt, who is going to be addressing the topic of UK's general strike, Brexit, and Walter Benjamin's critique of violence. Welcome, Patricia.
Thank you, James. And just to extend my thanks to James and to other faculty members for giving me the opportunity to present this working paper. I hope everyone can hear and see me okay. Now, as I've indicated in the abstract, I intend that this paper will form one among a number of articles and book chapters in which I've sought to demonstrate the relevance of Walter Benjamin's 1921 philosophical text, Critique of Violence, to various contemporary problems. James has just mentioned one that was published, but in fact the most recently published of these appears actually in James's edited collection on terrorism and asylum. Now, there's one particular aspect of the critique of violence that is being worked upon in different ways in all of these existing and the planned future publications. And this is a proposition which is captured most strongly between pages 280 and 283 of the essay, of Benjamin's essay. And incidentally, I'm using the version of the essay which was published in 1986 in a collection edited by Peter de Mentz. And this is actually available open access on the internet. So in this part of the essay, and by way of discussion of the workers' right to strike, Benjamin tells us that the state feels itself most threatened by the exercise of those rights which it confers on private individuals. So it is threatened by the exercise of legal rights. And so in order to curtail the threat, the state is always poised to declare the use of such rights an abuse and to limit the scope of their application. And that's the theme that's been worked upon in different ways in the various papers. And so in this research paper, I explore the extent to which that particular insight helps us to understand the implications for the stability of the European Union of the UK's decision to exercise the right to withdraw from the Union. And that right was conferred on all EU member states by Article 50 of the Lisbon Treaty, which came into force on the 1st of December 2009. Now, in a moment, I'm going to set out as much of Walter Benjamin's critique as I think is necessary for you to assess whether there is any merit at all in my application of it to the Brexit case. And I would be very interested in your views as to how plausible this application is. But one potential objection may already have struck you. Benjamin's text concerns the relationship between the nation state and its subjects, private individuals mostly. The critique of violence did not and perhaps could not have anticipated the unique legal arrangement of the European Union, according to which a sovereign state would become a subject of a legal order. So we're used to a nation state like the UK being sovereign for which, and in command of other subjects, but certainly within certain spheres of activity, the uniqueness of the European Union lies precisely in the fact that it conceives of its member states as subjects over which it can, and frequently does, assert its supremacy. So arguably, the relation between member states and the European Union is not unlike the relation between private individuals and the nation state. And that's really, to accept that proposition is really at the base of my argument, or rather my argument falls if that proposition is not established. And this is what I'm saying, there is an analogy to be drawn. But nevertheless, noting this weakness, noting that Benjamin did not consider a legal system of the kind that the European Union represents, my task in the original draft of this paper, which I produced sometime in late 2017 or early 2018, the task mainly was to present a plausible argument to the effect that since the triggering of Article 50, since it triggered Article 50, the UK's position in relation to the European Union legal order has become structurally analogous to the position of Benjamin's striking workers in relation to the domestic legal order with which the critique was preoccupied. And hence, that's the reason for the original main title of the paper, which I've retained for this presentation, and that is the UK's general strike. So just one more important caveat before I progress to the main argument. One of my research areas is European Union law. I've taught and researched in that field for quite a number of years. But I'm not a UK constitutional lawyer, nor indeed am I an international lawyer in the broad sense. So there are, of course, many aspects of Brexit that I've not been able to consider and don't intend to consider at all, and certainly may not work in the context of the Walter Benjamin critique that I'm dealing with. And that's just to bear that in mind. So the important point here is that I have only been concerned with the impact of Brexit, the use of Article 50 on the European Union itself. I'm not, in this paper at least, in my research, I'm not even particularly focused on the impact of Brexit on the UK. It is about the effect of Article 50 and the use of Article 50 in the Brexit case on the EU itself. And so in the research, which can refer to some aspects in this paper, I focus on the key stages of the near 3-year period during which the UK has sought to withdraw from the European Union. That is from the point at which it notified the European Council of its intention to leave the European Union, and that was on the 29th of March 2017, up until the 29th of January 2020, which is when the European Parliament ratified the withdrawal agreement that was finally, after so many years, was concluded under Article 50, paragraph 2. So that's the period I'm looking at. And needless to say, I cannot, in the time allotted to me today, analyse all the key stages of this period. But I will make reference to a decision of the UK Supreme Court, which was made in 2017 in the Gina Miller case. And this case sheds light on the question of what a member state needs to do in order to comply with the Article 50, paragraph 1 requirement to give formal notice of intention to withdraw from the European Union. Okay, so then what is my argument in summary? What is being said here? Well, with Brexit being so prominent a feature of today's legal and political landscape, it's very easy to forget that for much of the European Union's history, it was thought that the unilateral exit of a member state from the European Union was just not possible. And I think we need to remember that position was the received wisdom until quite recently. Now, Article 50, which confers upon EU member states the right to withdraw from the Union, purportedly put these questions to rest. So the question as to whether you could leave or not was settled seemingly by Article 50. I'm not sure if that is the case, but for the purposes of this this paper, I'll accept that it did put these questions to rest. But even if it did, even if that's true, even if it can be said that Article 50 brought a degree of certainty over the question of the permanency or otherwise of EU membership, it also brought a very proximate threat to the European Union's supremacy and therefore to the EU legal system's very survival. And this is my argument. It brings this threat. The threat existed from the point of its ratification, but the threat became a reality when on the 29th of March 2017, the United Kingdom government invoked Article 50. And that is because I'm arguing that by invoking the treaty article, the UK became the first subject of the European Union that was legally entitled to challenge the European Union's right to sole rule over key areas of EU competence, including, importantly, in respect to the movement of EU citizens. So it became, at that point, legally entitled to challenge the EU's areas of competence in ways that it could not have been without Article 50. And so more broadly, and perhaps somewhat more modestly, as I've indicated in the abstract, what I'm arguing also is that the tensions and the conflicts which have attended the UK's decision to exercise the right that was conferred under Article 50, and I don't have time to go through all of these, but there were lots of conflicts, and these are all foreshadowed, I argue, in Walter Benjamin's essay. Although he didn't have the European Union model in mind, nevertheless, I'm arguing that everything that's happened is really captured in that essay. And taking the example of the workers' guaranteed right to strike, what Benjamin does in that essay is to examine the crisis brought about by the apparently revolutionary or extortionate use of a legal right by a subject of a legal order against the interest of the legal order which conferred the subject the legal right in question. So you're granted a right, the right to strike, the right to withdraw from the European Union, and the question is, how do you use that right And what Walter Benjamin says is that if that right is used with a revolutionary intent in mind, or even if it's used in order in an abusive or extortionate way, then this brings about a crisis in terms of the legal order. And I want to think of that argument in the context of the European Union. Now, what consequences will flow from what Benjamin describes as an objective contradiction in the legal situation, as is his terms, whereby the exercise of a legal right becomes, in his terms, violent, and those are the terms he used, well, those consequences are difficult to predict. In the original draft of this essay, I drew some conclusions on how what I allude to as the UK's general strike will impact on the free movement of European citizens. I was then prepared to argue that counterintuitively, perhaps, as a direct result of the Brexit conflict, the radical path indicated by recent decisions of the Court of Justice of the European Union in relation to the free movement of persons will accelerate, will expand. And that will then bring the European Union much more quickly to the realization of its promise of a core package of citizenship rights, which have been decoupled from the nation state. Now, I'm not now as certain of that conclusion, although I will point out that right now there are various legal challenges that seek to argue that EU citizenship exists post-Brexit, that for using various arguments, that even though the UK has formally left the EU, when it does formally leave the EU, that EU citizenship rights should still be held by those who currently hold EU citizenship. So that would be nationals of the UK and second country nationals who are currently holding EU citizenship. So we're already having quite an important debate, part of which has now reached the Court of Justice of the European Union, or will reach the court. That is suggestive that, in fact, I perhaps wasn't so far wrong in saying that one of the things that Brexit will do is to accelerate that process in which citizenship becomes entirely decoupled from the nation state, and actually also decoupled from the EU treaties. Right, okay, so there is the general argument. Let's now say something more about Walter Benjamin's critique of violence and why I think it's a useful text to think about the implications of Article 50. So Benjamin's text is about the relation between law and violence. And much of what he says about that relation is found in other theories of law. So, and I don't want to spend time saying very basic things about the relationship between law and justice, which the audience will know about even if they don't know Benjamin. So what I'll do is just focus on the parts of the critique that I think are particularly relevant to the Brexit case. But let's start with a classic statement from the critique of violence, in which Benjamin says, and I quote here, "All violence as a means is either law-making or law-preserving. If it lays claim to neither of these predicates, it forfeits all validity." End quote. So according to Benjamin and other theorists, violence is only ever justified as a means to bring about the law, and Benjamin talks of this as law-making violence, or as a means to subordinate the citizen to law, which he labels law-preserving violence. But immediately, of course, one must qualify these assertions with the intelligence that for Benjamin, violence as a phenomenon cannot be reduced or restricted to conventional understandings that would equate violence with the enactment of traumatic physical force. It means more than just force. But as well as appreciating Benjamin's more nuanced use of the idea of violence, we must also understand that although he uses the term legal system to describe what can be legitimately inaugurated and preserved through violence, he makes clear that legal system is not to be equated with, and I'm quoting here, not to be equated with legal ends or the legal executive. He means more than that. In the critique, legal system designates the entire political entity within which all ends, including legal ends, are pursued. And so arguably, until the inauguration of the European Union legal system, the nation state provided the classic instance of a legal system in the way that Benjamin speaks of it. And of course, as I said earlier, it was the nation state that the critique is concerned with. So for Benjamin then, a legal system may legitimately use violence to preserve its existence and its authority. But merely to deploy violence is not a sufficient guarantee of the legal system's survival. To ensure for itself the best chance of survival, the legal system must repel the use of violence by any person or entity subject to it. And that's what is meant when we say that a legal entity, say the state, say the European Union, holds the monopoly of violence. And they must hold that monopoly of violence if they're to survive. But a legal order loses its monopoly or is under threat in losing its exclusive right to deploy violence in circumstances that concerns us here, when exceptionally it confers upon a subject the right to deploy violence. And in Benjamin's view, it is precisely in this exceptional case in which a subject is given a legal right to exercise violence that the legal system sees the most potent threat to his survival. So to put this point in Benjamin's terms, in his own words, and I'm quoting here, by what function violence can with reason seem so threatening to law and be so feared by it must be especially evident where its application, even in the present legal system, is still permissible. End quote. So let's now get into the point. Let's focus a little more on what Benjamin, in the context of this argument, has to say about the legal right to strike, and how specifically the exercise of such a legal right can, in certain circumstances, be conceived of as violence. And I'm now going to quote a fairly extensive passage from the critique, which I feel bears particularly upon the Article 50 and Brexit case. And please forgive me for not reproducing this so that you could read it yourself. I will return to some of the words in that quotation, and I think it'll become apparent why I think it's relevant. So Benjamin says, I begin the quote, "Organised labour is, apart from the state, probably today the only legal subject entitled to exercise violence. Against this view, there is certainly the objection that an omission of actions, a non-action, which a strike really is, cannot be described as violence. Such a consideration doubtless made it easier for a state power to conceive the right to strike once this was no longer avoidable. But its truth is not unconditional and therefore not unrestricted. It is true that the omission of an action or service, where it amounts simply to a severing of relations, can be an entirely non-violent pure means. And as in the view of the state or the law, the right to strike conceded to labour is certainly not a right to exercise violence, but rather a right to escape from a violence indirectly exercised by the employer. And strikes conforming to this may undoubtedly occur from time to time and involve only a withdrawal or estrangement from the employer. And that's the end of the quote. Now, there's the words that, like severing of relations, a non-action, a withdrawal or an estrangement, that I think are important here. And the underlying argument that the right to strike, a withdrawal of labour, is not in and of itself violence, but it can become violent. Now, why do I think this is relevant to Article 50? And that is my point. I think that Benjamin's analysis of the latent violence of the right to strike presents us with a tool with which to read anew the text in which is expressed how a member state might sever relations with the European Union, and that's Article 50. Now, Article 50 consists of just 3 very short paragraphs. And in paragraph 1, simply states that any member state may decide to withdraw from the Union in accordance with its own constitutional arrangements. Paragraph 2 basically states that the European Council should negotiate with the departing state to set out the arrangements for its withdrawal. And paragraph 3 just states what the consequences of withdrawal is, which is essentially that the treaties, the European Union treaties, shall cease to apply to the member state, either once the withdrawal agreement has come into force or after a lapse of a period of time, subject to extensions. And that's really all it says. Over the 3-year period of Brexit, most aspects of Article 50 were tested in some way in either the Court of Justice of the European Union or in the UK Supreme Court. For example, the UK applied for and was granted 3 extensions under paragraph 3. There were questions raised over whether its original notification of withdrawal complied with the terms of paragraph 1. And also the Brexit case clarified a point on which Article 50 was entirely silent, and that is whether or not, once given, a notification of withdrawal can be revoked. Now, I can't go into all of these matters here, but what I do want to emphasize is that common to the right to strike, as analysed by Benjamin, and the right contained within Article 50 of the Lisbon Treaty, is the fact that both involve a withdrawal or severing of relations, using Benjamin's terms. It's about withdrawal or severing of relations. And more to the point, perhaps, until the coming into force of Article 50 in 2009, very recently, 11 years ago, neither member states nor their citizens, member states of the EU or their citizens, were granted the legal right to exercise violence against the legal system of the European Union. To be more precise, before the Treaty of Lisbon, there was nothing in the system of European Union law that was in any way analogous to the workers' guaranteed right to strike. And if we follow the logic of Benjamin's critique, and this is what I think we should do, we would then conclude that Article 50 posed a threat to the European Union legal order from the moment it was ratified. And there have been comments on Benjamin's article, and the most famous of which, and well known of which, is Jacques Derrida's Force of Law. And he speaks also of the strike as a ceasing of activity when describing that kind of act. But what's important is that for both Benjamin and Derrida, the strike is only apparently non-violent. And that was evident in the longer quote, and that's important. It appears to be non-violent, but actually we can think of it as potentially very violent. For both Benjamin and Derrida, the strike is only apparently non-violent. In the first place, the non-action of withdrawal cannot, without more, escape the category of violence, because as Derrida reminds us, force, violence takes many forms. And I quote from Derrida, he says, the force can be direct or indirect, physical or symbolic, exterior or interior, brutal or subtly discursive, coercive or regulative. So it's not just physical force. There's lots of ways in which we can conceive of violence. But as Benjamin claims, and I think most importantly for our analysis, is in some circumstances, withdrawal from the operation of a legal order may nevertheless be a form of passive violence in the sense that it amounts to extortion, those are the terms he used, or it may carry a sufficient threat to the legal system as to amount to the kind of active violence that might actually lead to the system's effective demise. And I'll explain how that works in the context of Brexit in a moment. But it's still important to say that a legal right which consists of a right to withdraw, such as the strike or Article 50, that has significant qualities. And the main quality is that because the action of withdrawal appears non-violent, the legal system may concede the right too readily. So that is one of the insights. It's anything that appears to be non-violent, like the action of withdrawal. The danger is the legal system concedes the right, thinking either believing it to be non-violent or seeing its non-violent appearance as a justification for allowing it to become a legal right. So just quoting from Derrida, he says, certain people may have thought that since the practice of the strike, this ceasing of activity, is not an action, we cannot here be speaking about violence. And that is how the concession of this right by the power of the state is justified when the power cannot do otherwise, end quote. And I think it's hard to resist the conclusion that some of the conflict over Brexit has occurred because EU officials have realized that this concession, the right to withdraw, was perhaps given too hastily, that the implications of Article 50 were not sufficiently thought through in advance. Almost echoing Derrida's observation, Eva Marie Popcheva of the European Parliamentary Research Service stated in 2016, I quote here, the introduction of the withdrawal clause, that's Article 50, was a compromise necessary in order to reach agreement on the constitutional treaty. It was a political signal to anyone inclined to argue that the union is a rigid entity which is impossible to leave. In other words, wasn't really thought through, no expectation that anyone would use it, certainly wasn't thought about as a potentially, as a legal right that could potentially be used in a way that would undermine the European legal order. And I think that is partly because of the apparent non-violent nature of these kinds of rights. Okay, I'm conscious of the fact that I haven't got more than about 10 minutes left, so I'm going to try and push this forward a bit. Where are we? What have I said so far? I think at this stage of the argument, all I have done is to suggest, and I hope in a way that's fairly persuasive, that in conferring upon member states the right guaranteed under Article 50, the European Union legal order has permitted its subjects to exercise violence in the precise sense in which the phenomenon of violence is understood in the critique. But what I haven't done yet, and what probably is the most important part of the paper as it develops and as the wider project, is to address the question of whether the UK's use of Article 50 was in fact violent. Yeah. So the right of withdrawal is only potentially violent, and we need to then ask whether it has been used violently, either as extortion or in a more revolutionary way, with more revolutionary intent. And according to Benjamin, such violence then, if it is violent, it's because it's abusive or revolutionary. And so you then need to ask yourself, well, how do we know whether the use of a legal right is abusive or revolutionary? What are the signs? What's the initial sign that suggests this may be either an extortionate or revolutionary use of a legal right? Well, according to Benjamin, or at least my understanding of Benjamin's text, the factor that signals potential abuse or revolutionary intent is the use of a legal right in ways that were not intended. And this is around page 280. If you use a legal right in ways that were not intended, that signals potential abuse or revolution, although of course you still need to go a bit further. Now, how do we apply that to Brexit? Well, I think the suspicion of abuse or worse has attended the UK government's proposed actions in pursuance of the right guaranteed under the Lisbon Treaty, Article 50, ever since the UK electorate delivered its surprising answer to the Leave or Remain referendum question. And the first indictment against the UK was that its proposed mode of exit from the European Union was not compatible with its own constitutional arrangements and therefore was not in accordance with a core requirement of paragraph 1 of Article 50. And this brings me to the case decided by the UK Supreme Court, the very famous Gina Miller case. And here, the court did not support the UK government's position that ministers were entitled to exercise their prerogative powers as a way of complying with Article 50, concluding that legislation was required before notice of withdrawal could lawfully be given. The majority of the court reasoned that a prerogative power could not be deployed when to do so would bring about, and I quote, or paraphrase rather, a fundamental change to constitutional arrangements in the UK. The UK's withdrawal from the EU would result in the loss of an important source of UK law, and it went without saying that one of the most fundamental functions of the constitution of any state is to identify the sources of its law, and that's the end of the paraphrase from that case. So that was the Miller case, a very important case. The first way in which it might have been suggested that the UK were using Article 50 in ways not intended. But concern over the UK government's use of Article 50 did not end with its proposed procedures for exiting the Union. European Union officials were vociferous in their criticism of what they perceived to be an uncooperative and evasive approach by the UK toward its financial commitments, for example. And probably the most intense level of criticism of the UK was directed toward the various proposals advanced in respect to transitional immigration arrangements. Now, all of this, the Miller case and the discussion over citizenship rights and immigration rules and so on, these happened at the very early stages of the UK's attempted withdrawal from the EU. But there's further evidence that the UK was engaged, in my view, upon a general strike, that is, i.e. it's a revolutionary gesture. And the only one I have time to briefly consider here is the Brexit White Paper of 2018, which represented the UK government, this time under Theresa May, the first stab at conceiving of what the relationship between a newly independent UK and the legal entity of which it had been the subject for almost 50 years would look like. And I need to do some more work on this text, on the Brexit White Paper, but my initial reading leaves me in very little doubt that the UK was not intent on a passive withdrawal. It wasn't intent on leaving the EU quietly and with dignity. Rather, it sought to dominate the Article 50 negotiations in an attempt to modify the legal situation of the EU. And that's what Benjamin means when he talks about a revolutionary intent, an attempt to modify the legal situation of the EU. And especially telling in this regard is the fact that the Brexit White Paper often adopts a narrative style in which the UK and the EU are presented as entirely equivalent entities. For example, the document asserts that new government arrangements must, I quote, reflect the UK and the EU's status as key global players. And the paper boasts that the UK and the EU have set the global standard in terms of protection of human, animal, and plant health. And there's many other examples of this seeming equivalence. When it is not asserting that it alone, i.e. the UK alone, is equal in influence to all 27 members of the EU, the Brexit White Paper then asserts the UK's moral authority to govern. For example, claiming that the UK has always operated higher standards than the EU collective, supposedly shaping the EU's rules throughout its membership. I'm quoting from the paper. There's many more examples of this, and I just don't have time to go into too much detail. But these are, I think, examples, and there are many others, from which I argue that in its use of Article 50, the UK was not intent on a passive withdrawal from the EU, but rather, in a revolutionary gesture, it has attempted to appropriate and present as its own some of the EU's founding principles. What are these? At the foundation of the legal order that we call the European Union lies the promise of a permanent species of individual rights, the force of which is such as to confound any rival claims and inducements of the nation state. And this founding promise is constantly repeated in the judgments of the Court of Justice, particularly judgments pertaining to the principle of the free movement of persons. I don't have time to provide an overview of this jurisprudence about the free movement of persons within the EU, but suffice to say at the moment that the UK has always shown itself to be less than faithful to this founding promise while it was a member. The UK often exempted itself from several of the EU's laws and policies relating to the movement of persons. Ostensibly then, through Brexit, the UK sought to escape entirely from what it perceived in the EU's jurisprudence as a form of discursive violence. And there are several examples of such justification for the Brexit vote and for the UK government's stated determination to give effect to that vote. In stating that the UK's intention to take back control of its borders, the claim that the free movement rights had exceeded or supplanted the founding treaties was a constant refrain. It was said that free movement rights were exercised in disregard of the intentions of member state governments, and it was claimed that after several failed negotiations, only a complete withdrawal from the European Union would enable appropriate levels of border control. So these were the arguments for Brexit, and they were arguments against the EU's founding promise. And yet, as evidenced in the initial stages of the Brexit negotiations, the UK's planned exit came with a demand that UK citizens and second country nationals resident in the UK would continue to exercise free movement rights after Brexit, that is after, according to paragraph 3, the EU treaties would no longer apply. So by its insistence in the early stages of the Brexit negotiations that free movement rights of its nationals can and should remain fundamentally unaltered post-Brexit, I would say that the UK has at the very least introduced an element of extortion in the Article 50 bargaining. But has it gone further? I say yes. I think it's done more than indulge in more mere extortion, because all along the UK, while it was a member, the UK has sought to keep in abeyance the EU's founding promise, has undermined that promise. But now it seeks to fulfill that promise for UK citizens and second country nationals resident in the UK. And we might then say, in the terms of Benjamin and Derrida, that the UK seeks in this double gesture to appropriate the EU's core idea of citizens' rights that exceed their instantiation in any single treaty. And in doing so, in trying to appropriate that notion, the UK has revealed its revolutionary ambitions. So to conclude then, I think I have a lot more work to do, but I think there is a case to be made for the use of the critique in this context. I think there is a case to be made that the UK's referendum process, its attempt to initiate the Article 50 process in disregard of its own constitutional arrangements, and its approach to the broader negotiating process, all of this indicate the deployment of the right contained in Article 50 in a way that was not intended. Benjamin marks such a deployment as violence because it constitutes an abuse. Derrida speaks of a misinterpretation of the original intention. The UK would refute the suggestion of either abuse or misinterpretation and would claim simply to be exercising a right which all member states acquired with the Lisbon Treaty. I'm paraphrasing now from Benjamin. In this difference of interpretation between the EU legal order and the UK is expressed the objective contradiction in the legal situation, whereby the state, in his terms the state, acknowledges a violence whose ends it sometimes regards with indifference, but in a crisis, such as a revolutionary strike, it confronts hostilely. If the use of Article 50 by the UK is a threat to the conservation of the EU, it must be understood that it is the fact that the UK is exercising a legal right that gives the threat potency. Unlawful, even criminal actions could not threaten the EU, as does potentially at least the use of Article 50. Derrida reminds us that the threat does not come from outside. Law, he says, is both threatening and threatened by itself. Thank you. Thank you.
Thank you very much, Patricia. We'll now open the floor for questions and discussion. I see a question in the chat from Philip McEwen. Philip, do you want to unmute yourself and just ask the question?
Well, there's an underlying analogy that's presupposed by the paper. I enjoyed the paper very much. Well done. There's an underlying analogy. And the problem with analogies is that they don't pay much attention to disanalogies. That's the weakness of analogical arguments in general.
Yeah.
So I'm trying to bring out the disanalogy in your analogy.
Thanks.
One of those analogies. So I'm looking for comments. Unlike strikers who are employees of the companies against which they strike, member states of the EU are not employees of the EU, in which case they cannot go on strike against it, nor do they have the right to do so. Comment?
Yeah. Do you want me to comment on that? Yes. I mean, I do accept, to start with, that in a way my argument stands or falls on the acceptance that you can think about the member states of the European Union in a way that you can think of a subject of a nation state. So, I do accept that point. I think the point about the strikers as particular subjects, I think that I'm not as persuaded by that, because what I'm trying to draw from the example of the strike is the nature of the legal right in question, and that is to say, what the analogy is between is really about Article 50 and what Article 50 allows a member state to do. That is to withdraw from the European Union, to sever relations. And I think it is that severing of relations that really Benjamin is working upon, to say to what extent can that have revolutionary potential, to what extent that can be violent. So I entirely accept your point that even if you can say, as I think you can, that member states are subject to a broader, a superior legal order, that they're not employees, and therefore you can't make that direct analogy. I do accept that. I think it's not quite that analogy that is important in Benjamin, because he just says that the strike, the organized labor, is the only exception he can find where the state confers on a subject the right to deploy violence, and so to the extent that I'm making an analogy, it's saying that in the history of the European Union, the only example I can find of where the European Union has allowed its states to exercise violence in the way that Benjamin thinks of is in 2009, when Article 50 came on the books. But I take your general caution. I think I have to do a lot more work to say that Benjamin, is useful. And of course, there are other theories that might work better. And it's possible that, you know, I might have to abandon that. But at the very least, I probably should make it clearer that what I'm taking from Benjamin, and it's about a legal right that is a right of withdrawal. I think that's more what I'm focusing on. And I think you're right that perhaps I haven't made that clear, that it's not the employment relationship as such, but the nature of the legal right in question. Does that at least partly answer your question?
Well, thank you for the clarification. Yeah.
Thank you.
Are there any other questions or comments?
I have, pardon me, I have a question, Patricia. I wonder if you could clarify something. You said that the Article 50 was used, or perhaps I didn't understand, the withdrawal clause, it was used in a way that it wasn't intended when it was written. I wonder if you could explain that a bit more.
Yeah, okay. So I wasn't able to give too much example. I mean, the important point about the using the legal right in ways is not intended is that, from my reading of Benjamin, it is that which signals a potential violence, yeah, in the using violence in the broader sense. And so, of course, it does leave the question as to who decides what was intended. And I see that as an issue. Of course, Britain is is the only country that's used Article 50. So anything that we know about Article 50, its scope and interpretation has really just come from the Brexit case. But what I think is not unreasonable to argue is that what was intended in Article 50 is that a member state would simply passively, if you like, withdraw. And having exercised the right to withdraw, basically they become in the same position as another third country. And that's all that was intended. Whereas in what I'm arguing is in Brexit, and how the UK has used Brexit has been in ways that it's not about a passive withdrawal. I needed to go into much more detail about the negotiating process, and in particular the Brexit White Paper, but there's been much more of an attempt to use Article 50 to change quite fundamental aspects of the working of the European Union. And the fact that it might be a failed revolution, I mean, we still don't know what the outcome of Brexit, but it may be this is more likely that this is a failed revolution, but I don't think that alters the general argument about how the article was used. Does that clarify?
It does clarify. As what I've seen in Canada is that, I mean, the Brexit has been more or less a bit of a disaster since the referendum. So is it possible that, and the referendum, as I understand it, there wasn't much of a majority. There wasn't a very it wasn't like a 79% or an 85% majority.
Between the two, yeah, 48, right. Something like that.
So is it possible that some of the way the UK is behaving is just as a result of internal political issues? Because, you know, that's, as you said, it's not a very commanding majority for something that's, you know, so important.
I think that's true. I think that's a fair point. You know, you could say from the start, and even probably this would be admitted by the politicians that were in charge, that the expectation in any event was that there wouldn't be a referendum to start with. That was more of a gesture, and I think at the time that the Conservatives didn't think they would get the majority in the general election that would allow them to even put the referendum question on the paper. So there was an accident there, you might say, and certainly Parliament, who were in charge of the Brexit process, the majority were for remaining within the European Union, and therefore had to then negotiate their personal positions with the positions of the electorate. So there were all sorts of problems. And in a different paper that was published a few months ago in Law and Critique, I do look at really this as an accident, and what's the effect of this kind of accident, and which I think Brexit is in some ways. So I do accept that. I don't think in terms of Benjamin, though, that the argument is necessarily affected, or rather the argument doesn't really depend on a sense of, if you like, a single-minded purpose. And I think that has to be the case, given that his analogy was the strike, where there might be several minds and several interpretations. So I certainly think you can still make the argument about revolutionary intent or abuse, even though you accept that there's a certain reluctance in that. Having said that, I agree that there's other ways in which you can analyze Brexit, and has been done. And, you know, there's some of the more, some partly persuasive, but certainly popular arguments is really about the sort of empire mentalities that are, that is certainly significantly at play in the UK, but also in the EU. And I think that's a perfectly plausible way of thinking about what's happening in Brexit as well. So I certainly don't want to suggest that this is the only viable way. But what interests me with Benjamin's text, and you know, this is what I focused on in all the pieces that I've looked at, is just this important insight, I think, that it's the exercise of legal rights in ways that are problematic, that is the real threat. Whereas we tend to think of threats being in terms of, you know, unlawful activities and criminal activities and so on. And that's why I was quite attracted to that. But thank you for that. Thank you for that. And just to remind everyone, this is very much a work in progress. So I'm actually very grateful for any contribution that sort of points to some of the weaknesses in the arguments and might indicate that there are different ways of looking at what happened in the 3-year period. So that's very helpful. Thank you.
Thank you, Patricia.
Patricia, I wonder if I could ask you a question. I'm going to abuse my responsibility as moderator here. Max Weber makes the argument that the state has the monopoly on the legitimate use of force, and that I'm assuming that the critique underlining Benjamin's work with respect to violence is slightly different, because am I wrong in assuming that violence is beyond force itself, or the legitimate use of force, and that would apply to the law, because doesn't force itself have to be harmful, either to the individual or society? And I guess you could say all coercion is, in fact, it can be violent because it goes against the free will of the individual himself. But if it's harmful to others, then perhaps it is legitimate. So we do constrain the individual. So I'm just wondering to what extent something like one would assume, if it's a democratic process and a fair process that comes to a conclusion that no one really wants, but comes out of the referendum itself. Does that then imply that the legislature has to proceed and the government has to accept the legitimate outcome in terms of the electorate? And by doing so, it may be coercive because people oppose it, but it's not necessarily violent. So I'm just wondering if you could respond to that.
Yes. Well, first response is I don't know enough about Weber. I don't know as much about Weber as I think I should. So that's what one, and it's an area that I would do want to work on a bit more. So to that extent, my answer might be a little bit limited. It is true though that one of the key things in relation to the use of the example in Benjamin, and one of the reasons why I'm attracted to it, and also to Derrida's supplement of Benjamin, is that it is challenging us in terms of what we think violence is, and he does acknowledge that. In that, I'm sorry that I didn't reproduce the quote so you could all read it, but he is saying that, you know, that mostly a strike isn't violent. It's a passive severing of relations, but really wants to emphasize that it can be. And this is the general strike that he thinks of in terms of violence. I think it is challenging in terms of what we understand violence to be. I mean, the only other thing that I would say, I don't know enough about Weber, but the only thing that's striking about the Benjamin text is that he's trying to set out a criterion for the exercise of violence that's in principle, which he specifically says is not, we should be able to accept it as a criterion without thinking of individual cases of its use. So we should be able to understand when violence is justified without looking at particular instances of violence. And it might be a difficult thing to say, but that's what he's trying to do. So this is why he comes to the conclusion that you can only justify it to preserve, to inaugurate law or to preserve law. And it's not a moral case, it's just saying that as a matter of principle, violence can only be justified to bring about law or to preserve law. And any other use of violence is problematic. And then the rest is talking about why it is that a legal system has to prohibit the use of violence by individuals. And that's all about the monopoly of violence that Weber, of course, talks about. But yes, I do think you do have to, even more so with Derrida, who talks, you know, sometimes too expansive of terms, even for me, about what violence can be, when he talks about discursive violence and so on. But then even that, if you think of how case law works, and this is the point about the European Union body of jurisprudence, which is all about its supremacy, which is all about repeating that the EU law is a new legal order for which member states are its subjects and EU law is supreme. And this is what the jurisprudence is about. And I can see how you can think about that as a kind of violence, in the sense that it's about the preserving of the EU of EU law. So it's a legitimate violence, but it has that function of preserving its authority by constantly repeating its supremacy and underlying its supremacy. It's a way of preserving its authority, and it's in sort of using the Derrida argument, it can be seen as a kind of discursive violence in that it's effective and you know, can be quite oppressive. And so, but yeah, I mean, again, to take from that, I think I had been thinking about looking a bit more about Weber in terms of this understanding of violence and the state monopoly of violence and so on, and that's something I will do. So thank you for that.
Just another side comment or a quick question, because this is the first time I've ever heard of it, so thank you very much for pointing it out. You mentioned that despite the fact that the UK is now leaving the European Union through Brexit, somehow the EU citizenship is still retained. Was I right in hearing that?
Well, not that it has been, but there's a number of attempts. In fact, there's certainly at least one case that I know that's pending in the Court of Justice, which is attempting to argue that. So there's been quite a lot of discussions, certainly at the beginning of the negotiations. So what the European Commission were suggesting some kind of associate citizenship and so on. I think that argument has fallen by the wayside. But since then, there have been some legal attempts to argue using various grounds. Some, you know, I'm not familiar with all of them, that for all sorts of reasons, even when we leave, those who have EU citizenship at the moment and probably have exercised it, I'm not quite sure what the scope would be, but should be allowed to retain their citizenship. And you know, it may seem like a curious argument, but the European Court of Justice have been moving in the direction of, with a number of important judgments, where it does look as if they are decoupling citizenship, EU citizenship, from the treaties. So suggesting that there's something that exceeds the treaty. Now, they haven't got as far as some would like, and certainly not as far as, I mean, they're certainly not as far as saying that a member member who leaves the EU, that their citizens would retain citizenship. But there has been quite a respectable body of scholarship that well before Brexit had been arguing that certain legal rights, European Union rights, exceed the treaty. And I guess it's a sort of analogous, I'm sorry, I've been cautioned about using too many loose analogies, but perhaps a bit like the notion of customary international law. I mean, wouldn't that be an example of rules that begun with it in a treaty, but have now said to have exceeded the treaty, so that even states that are not signatories may still be bound? And I think, like the Article 33 non-refoulement principle has been argued by some as being one of those. So I think it's that kind of argument that's being used. So yeah, watch this space. It may well be that those arguments fail, but they're definitely genuine and attempts to rescue some form of citizenship for British nationals post-Brexit. But nothing's yet been decided.
Thank you very much. That's really interesting. I wasn't aware of those arguments. Thank you. I think we've exceeded our time. I'd like to thank, first of all, of course, Patricia Tuitt for being with us here today in her very interesting paper. And I'd like to thank all of you for attending as well. And I'm very hopeful that Patricia will be back with us again at some future point.
In person, I hope.
Yes, in person, absolutely. You must visit us when they allow travel again. But I want to thank everyone else for attending as well, and remind you that our last McLaughlin College lunchtime talk will actually be our UN International Human Rights Day, and that's a commemoration, and that's tomorrow. So please try to attend that as well. So thank you everyone for joining us today.
And thank you all as well for listening, and also for some very helpful and interesting questions. So thank you. Thank you, James.
Thank you. And we hope to see you all again, if not tomorrow, then in the new year when we start our next round of lunchtime talks. Thanks very much, everyone.